Do you, I think you recorded. So thank you for accepting our invitation, and you can also share your screen, so you have access for that. Yumi will present her paper on arbitration. So you have 1 hour and 15 minutes, and we will ask you questions during the presentation, and you can start. Thanks a lot.
Okay. Me trying to make sure I can get this. Oh, there we go. Okay. Well, thank you very much for giving me this opportunity to present this work here. This is joint work with Bernardo Silveira, who is a alumnus of your department, and Xuan Tang, who is a colleague of mine at Rice University. And we are going to talk about risk and information in dispute resolution, and we're going to be looking at arbitration. If my internet gets choppy during the presentation, just let me know and I'll try to repeat whatever I said. Okay. This paper is a study of arbitration, and arbitration is a private dispute resolution process where a third party called an arbitrator makes a decision to resolve the dispute. So you can think of this as a private sector analog of the court system, but it's cheaper, it's faster, and it's less formal. And another difference is that arbitrators tend to be experts in the subject of dispute, unlike judges in the court system who are typically generalists. Arbitration is very widely used. It's used in labor disputes, commercial disputes, civil disputes, and international disputes. And in fact, there was a 1998 survey of the legal counsels of the 1,000 largest US corporations, and the survey found that 79% of them had used arbitration. Another interesting thing about arbitration is that it is a prototype for quantitative analysis of dispute resolution. And this is because, as we will see, arbitration is a relatively well-defined game. So it's well suited for leveraging theory to garner insights. So our goal in this paper is to bring an arbitration model to the data in order to first understand the role of uncertainty and risk aversion in arbitration. So in general, there has been concern about asymmetries between the parties who are in arbitration. And there can be many different types of asymmetry, but one type is that one disputing party may be more risk averse than the other. So we would like to analyze how risk attitudes, or asymmetric risk attitudes in particular, affect arbitration and negotiation outcomes. I mentioned negotiation here because negotiations for wages happen in the shadow of arbitration, because arbitration happens when negotiations fail. Another goal we have is to compare different arbitration designs. The two most popular designs of arbitration are final offer arbitration, which I will refer to as FOA in this presentation, and conventional arbitration, which I will refer to as CA. Okay, so the difference is that to make things concrete, think of a labor dispute. So there's a union and an employer. In final offer arbitration, the union and the employer each make or submit a final offer, and then the arbitrator is constrained to choose one of these offers, either the union's offer or the employer's offer, as the final award. Okay. In conventional arbitration, the union and the employer similarly officially submit an offer, but the arbitrator is not constrained. There are no constraints on the arbitrator. It turns out, as I will explain later, that conventional arbitration is a cheap talk game, but final offer arbitration is not. So we would like to analyze how these different designs of arbitration affect the behavior of the disputing parties, the arbitration awards, the extent of information revelation, efficiency, and I'll define efficiency later, etc. So in this paper, we develop a model of strategic interaction between the two disputing parties, so the union and the employer, to make it concrete, and the arbitrator. As you can tell from the title of the paper and the main research questions that we have, there are two features of arbitration that are central in our analysis. One of them is that the parties may not be risk neutral. And the other is that the arbitrator infers information from the disputing parties' actions. And the relevance of these features in arbitration is attested to in the preceding literature. We will characterize equilibrium properties of arbitration, taking seriously the fact that the disputing parties' offers are strategically chosen. We will also model a negotiation stage that precedes arbitration, and our goal for this is in order to give some insights on how arbitration affects negotiated outcomes, given that the negotiations happen under the shadow of arbitration, meaning that the parties know that if the negotiations fail, they will end up in arbitration. We formally establish identification of our model, and then we will use it to study wage negotiations between police and fire unions and their employers in New Jersey, the state of New Jersey, during 1978 through 2000. That data actually consists of a few different components. One component is arbitration data from 1978 to 1995 that we obtained from Ashenfelter and Dahl. There's a policy change in 1996. So we supplement that data with arbitration data from those later years, from 1996 to 2000. And we also collect data on wages that were negotiated under the shadow of arbitration for this whole period. So that's all of the data. Here's a preview of what we find. When it comes to the union being risk averse versus it being risk neutral, we find that the union's risk aversion leads to higher arbitrated wages. So if you just look at arbitration in isolation, the union's risk aversion actually helps it get higher wages, but it leads to lower wages overall when you consider this two-stage process where there's a negotiation stage that precedes arbitration. And second, when we compare these different arbitration designs, we find that relative to final offer arbitration, conventional arbitration leads to the following things. More divergent offers from the disputing parties, meaning that the union and the employer's offers in arbitration are further apart. It leads to inferior information revelation from the disputing parties to the arbitrator, meaning that the information that the disputing parties are able to convey to the arbitrator is not as precise in CA versus FOA. In CA, the arbitration awards have lower variance though. And on balance, the arbitration awards are closer to the fair wage on average in conventional arbitration. So we'll dig into those details in the later part of the presentation.
Yumi, can I ask you one question?
Yes.
I don't know if it's a good question, but I'm trying to understand the difference between the negotiation and the arbitration, and if they know when there is an arbitration.
Oh, okay, yeah. So negotiation is just something that happens between the union and the employer where they're trying to settle on a wage. If they fail to agree by a certain time, then the law says they must go to arbitration, where there's a third party called an arbitrator. It's kind of like a judge that the two sides must submit their official positions to. And then the arbitrator or judge gets to decide the final decision, and it's binding. And this is by New Jersey law. Does that clarify?
Yeah, yeah. Mm-hmm.
Yeah.
Yunmi, let me try to understand the contribution here. You know, looking at the list that you provide here on the key results, it seems to me that the last one is probably the most unexpected, right? In the sense, it will lead to something that is closer to a fair wage, even being a kind of a cheap talk. Is it because there is a kind of a bias that is created as the risk aversion differs among the different players? What's the intuition behind this particular result here?
Yes. So there's two forces leading in opposite directions, I guess. On the one hand, when you look at which side, which design leads to better information revelation, it's FOA, final offer arbitration. But FOA has this big constraint on the arbitrator, where the arbitrator must choose either the union's offer or the employer's offer. So this leads to higher variance in the awards in FOA. So then that leads to, it constrains the arbitrator.
I see.
The arbitrator is not able to, in a way, it cuts out the middle. And so these two forces lead in opposite directions. And we find that in our application, this is not a theoretical result, it's an empirical.
Right, yep, I got that. Yep.
Find that, yeah, the awards are closer to the fair wage on average in conventional arbitration. Yeah.
Okay. And to what extent do you think that this framework is related to this particular context or other kinds of disputes that would use similar procedures?
Yes. So one thing that we think could be like a future related research question is, for example, in criminal justice, when judges make rulings, there have been policy debates about how constrained should the judge be in reaching making a decision on how long should the sentence be, et cetera. There have been policies that propose more constraints versus less constraints. And it's not completely the same, obviously, but it's a little bit related to this idea of, you know, different designs that put more or less constraints on the third party decision maker. So I think that would be an interesting area.
Okay, thank you.
Hi, Yumi, may I ask a question?
Yes.
Yeah, about this first result on the union's risk aversion. So I understand this is an empirical result as well.
Yes. Yes.
And so I was curious, how did you get data? How did you get data about risk aversion?
Oh, so risk aversion is something that we are going to estimate. And so that I will defer to a little bit later for how we identify the risk aversion.
Great, thank you.
Okay. So briefly on the literature, obviously our paper relates to the literature on arbitration, which goes pretty far back. The oldest paper that we're going to cite today is from 1966. We were heavily influenced by, in particular, Farber 1980 and Gibbons 1988. And we, as I mentioned earlier, we also obtained data from Ashenfelter-Dahl 2012. Many of the questions that we have require identification of model primitives. And to our knowledge, ours is the first attempt to bring an equilibrium model of strategic interaction to the arbitration data. So in that sense, our paper is related to the strand of literature that takes a structural approach to studying bargaining and dispute resolution. And we cite some papers there that are in this line of the literature. So that's my introduction. Without further ado, I'll briefly introduce the data. Just as a heads up, in this presentation, I'll spend most of the time of the presentation discussing the model and the post-estimation analysis. I'll be relatively brief about the data and about identification and estimation, although I will spend some time on it. Yeah. So here's the data that we're studying. These are police and fire contract negotiations in New Jersey, so police officers and firefighters. The New Jersey local governments, these are municipalities, they must renegotiate their contracts with the police and fire officer unions roughly every 2 or 3 years. And the major issue that is at stake are the wage increases for these employees. If negotiations fail, the law prohibits these workers from going on strike. Instead, the law says that they must proceed to final offer arbitration. And this system was in place from 1978 to 1995. And the process was supervised by an official New Jersey public organization. Okay. In 1996, there was a policy change where conventional arbitration replaced FOA as the default. We will use this conventional arbitration data in our post-estimation analysis, but we are actually not going to use this in identification, just as a heads up. So for now, let's focus on FOA and let's kind of ignore conventional arbitration for now. Yes.
Yunmi, just a clarification question here.
Yes.
When they sit to set up this, to negotiate these wages, or when they have an idea about the arbitration process, they know who will be the, I don't know, the name of the person that will make the final arbitration, the final choice. Is it public information? Do you have some expectations about, possible bias of these?
Yeah.
People? Is there a variation over time?
Yeah, that's a good question. So both the union and the employer have input into which arbitrator is chosen. So basically, they're given a list of names. Both sides are able to strike out any arbitrators that they feel like striking out. And then of the remainder, they rank them. And the arbitrator that has the highest combined rank from the union and the employer is chosen as the arbitrator. We've also run some regressions, regressing the arbitration outcome on the identity of the arbitrator. And we didn't find any significant arbitrator fixed effects. And that's consistent with what the preceding literature says for New Jersey public arbitration. They find that the arbitrators, you can largely consider them as exchangeable, and they don't seem to be biased.
Okay, good.
And hi, Yunmi, can I ask you a question? How is the arbitrator chosen, and who is the arbitrator?
Oh, so both the union and the employer are given a list of names of arbitrators, potential names, and then both the union and the employer can cross out names that they don't like. Then they rank the remainder, and the arbitrator that has the highest combined rank from the two sides is chosen as the arbitrator of the case.
So it's a private firm.
The arbitrator is like they're like kind of self-employed a lot of the time. It's a person.
It's a person. Okay.
Yeah, they're
And
like a
why not?
professional.
Right. And why not a judge? Because the arbitrator knows more about the topic.
Yes, typically arbitrators are experts in the subject matter, and judges are not. So since our estimation focuses on final offer arbitration before the policy change, that's our estimation sample. The data in that estimation sample consists of two pieces. One, it's the data on all the arbitration cases that we obtain from Ashenfelter and Dahl 2012. What's the main data that contains? It gives us the final offers that were submitted by each party to the arbitrator, and it tells us which of those offers the arbitrator chose. Remember that in final offer arbitration, the arbitrator must choose either the union's or the employer's offer as the final award. Also, we collect data on the negotiated settlements that were reached without resorting to final offer arbitration, without going all the way to arbitration. And so what's the main data we see there? We see the negotiated wage increase amount. Okay. And of course, we also collect a bunch of covariates from various sources like local demographic and economic variables. Here are a few summary statistics just to give you a sense of the magnitude of the wage increases we're looking at. So the average arbitrated wage increase is about 7.2 percentage points. The average negotiated or settled wage increase was about 6.6 percentage points. As you can imagine, it turns out that the union always submits a final offer for a wage increase that's higher than what the employer offers. And the average difference is about 1.7 percentage points. When we look at, so because the arbitrator must choose either the union's or the employer's offer, if the arbitrator chooses the union's offer, we say the union wins. And if the arbitrator chooses the employer's offer, we say the employer wins. When we look at the union to employer win rate, it's about 60-40. So the union wins more than half of the time in this data set. Okay, so as I said, oh, sorry, did someone have a question?
Yeah, just a quick one. So the arbitrator only decides about the wage increase, or he decides about the whole package?
Yeah, so good. That's a good question. So when we look at these contracts, one thing that is notable is that the New Jersey law says that things that are under the legislature's control or legislating authority cannot be negotiated. So for example, things like pensions, they are under the legislature's authority, so they are not allowed to be negotiated in this. So when we look at what other issues come up for actual negotiation, they tend to be, the most common things are holiday schedules and uniform allowances. But the consensus is that the wage increase is the most important component. And so that's what we are going to be focusing on here. So in practice, it is multidimensional in the sense that there are things like uniform allowances and holiday schedules that might be also negotiated, but wages are the predominantly important thing.
Yeah, my concern was just that, these other amenities could be, like important as well. So,
Right.
like for the fair,
Right.
ruling.
Yeah. You're right. So that could be a source of a bit more noise in this. Okay. So as I said, I'm going to be pretty brief on the data because the model takes a long time for me to get through. So I'm going to move now to introducing the model that we're going to try to bring to this data. We have two parties, the union and the employer, and they are in dispute over this wage increase that we will denote by Y. For the preferences, we're going to let the union have CARA utility so they can be risk averse, risk neutral, or risk loving, depending on what that parameter is. We're going to let the employer be risk neutral. The wage increase Y is going to be set by the arbitrator, who's a third party. What's the arbitrator's goal? Well, the arbitrator's goal is to try to set the wage increase as close as possible to some notion of the fair wage or the fair wage increase that we will denote by S. Now, this fair wage S is not known with certainty by anyone involved. So this model will involve the arbitrator trying to learn whatever she can about what the fair wage should be. The fair wage has a prior distribution that's normally distributed with a mean M and precision H. Precision, just as a reminder, is just the inverse of variance. But in this presentation, I'm going to be talking about precision more than variance because the model will involve learning. And in models with learning, it's just easier to talk about precision rather than variance. Consistent with the fact that there's this uncertainty, the players will perceive a noisy signal of the fair wage S. The arbitrator will receive a signal SA, which equals the fair wage plus a mean zero error, epsilon A. And the parties, the union and the employer, will receive a signal SP, which equals the fair wage S plus a mean zero error, epsilon P. And epsilon A and epsilon P are normally distributed around 0. We're going to assume that epsilon A, epsilon P, and S are mutually independent. Yes.
Yunmi, is there any reason to particular reason to assume that the precision is the same for both?
Oh, I see. The idea behind that was that we think there are some cases that are more uncertain than others. And so when a case is uncertain, there's more noise for everyone, both the parties and the arbitrator. So that was the idea behind that modeling.
Okay.
Yeah. And just to clarify, when we say the parties receive signal SP, we mean that the union and the employer receive the same signal SP. So that in that we are following Gibbon's signal structure, where in this arbitration literature, the primary dimension of incomplete information that they focus on is between the parties and the arbitrator. So the arbitrator doesn't know the party signal, the parties do not know the arbitrator's signal. And we think that the reason for this emphasis in the literature is that when we talk to practitioners in New Jersey, they tell us that when the two parties write their final offers, they actually, there isn't really any information that one side knows that the other doesn't. And the two parties actually know fairly well what offer the other side will submit. So we think this is what motivates the literature to focus on incomplete information between the parties and the arbitrator. In our empirical application, we let this signal precision that we call H epsilon vary across cases with some distribution that we call G. Okay. Here's the timeline of the arbitration model. So first, the parties will observe their signal, the arbitrator observes her signal, and then the union and the employer will simultaneously make their final offers. The union's final offer we call YU, and the employer's final offer we call YE. And upon observing these offers, the arbitrator will update her beliefs about the fair wage S, and then will set either Y equal to YU, so she'll choose the union's offer, or Y equal to YE, she'll choose the employer's offer. And again, this must be the case by the rules of final offer arbitration. What's the arbitrator's problem here? Well, the arbitrator has two sources of information then upon which to base her beliefs about the fair wage. One is her own signal, SA, and the other is the information about the party's signal that is conveyed by their final offers. So let's denote the arbitrator's updated expectation of the fair wage as YA, which is a function of the SA, YU, and YE. Once she forms that updated expectation, then the arbitrator will choose whichever final offer is closer to YA. So the arbitrator will select the employer's offer if YA minus YE is less than YU minus YA. So, but that's the same as saying that YA is less than the midpoint of YU and YE. Okay. So that's how the arbitration will decide once she forms her updated expectation. Of course, the union and the employer are uncertain about what YA is because they do not know SA. So then what are the problems that the union and the employer solve? The union would like...
Yunmi, sorry.
Yeah.
Sorry, so there is no... Presumably, you could imagine a situation in which the arbitrator could update her expectations about the wages once they observe the signals that will be sent by both parties, right? But here it seems that it's not the case, or am I missing something?
So
is the YA, is it dependent on the signals, on the actions that will be revealed by both parties or not?
yes, yes, it is, because YU is the union's.
Oh, it's there. Okay.
Yeah,
Sorry.
and the YE is the employer's offer, and so no,
Okay.
it's good. Good
It's a combination
clarification.
of this. Yeah. Okay. Thank you.
Yeah, so YA will be a function of all of these three things. Mhm.
Okay.
So then if you think from
Yunmi, can I just a quick question? So what about the negotiation before going to the arbitration? Are you going to be modeling that first step of the process, or?
Yeah. So we do have a negotiation stage model, which I will get to. Our main focus though is on this arbitration model, but we do have a negotiation stage model as well.
Okay.
Okay, so when you look at then the union and the employer's perspective, what they want to do is to maximize, for example, for the union would like to maximize the probability that the employer wins given the signal times the union's utility of the employer's offer, plus the probability that the union wins conditional on the signal times the union's utility of the union's offer, right? And we know that the probability that the employer wins is the probability that YA is less than the midpoint, as we were saying on the previous slide, midpoint of the offers, Y bar, that is. And the employer is solving an analogous problem, but just replacing the union's utility with the employer's utility function. So this is the problems that they're solving when they choose their final offers, YU and YE. So then what does equilibrium mean in this game? An equilibrium would mean that the union's offer function YU, the employer's offer function YE, and the arbitrator's updated expectation function YA, these constitute a set of mutual best responses. And in particular, when you think about, well, what are the different economic forces that the union and the employer need to balance as they formulate their final offer strategy, there are three big forces that they need to balance. One is that there is a gain from having a more aggressive offer accepted, meaning, for example, if you're the union, there is a gain from having a higher wage increase accepted. But second, there is a reduced probability of such a more aggressive offer being accepted, because when you're the union and you ask for a crazy wage increase, it's less likely that the arbitrator will accept that. Third, there's also an opportunity for both the union and the employer to influence the arbitrator's beliefs through this YA function. So those are the three economic forces that drive the final offer strategies. There is a brief bit of notation that I'll introduce before talking about the equilibrium offer strategies. Let me define the party's expectation, that is the union's and the employer's expectation of the fair wage, given their signal SP is MP of SP. And that is this weighted average of the prior mean of the fair wage, M, and their signal SP. And the weight of the signal relative to the prior mean depends on the precision of the signal and the precision of the prior. And as you would expect, the more precise the signal is, the more weight it gets in informing this updated expectation by the normal learning model. So having defined that notation, we show in the paper that there exists a separating equilibrium in which the union's final offer is going to equal MP of SP plus some amount delta U, and the employer's final offer is going to equal MP of SP minus some amount delta E. So the parties will take divergent positions strategically, and the terms delta U and delta E, they do not depend on SP, and moreover, delta U and delta E are unique given the model parameters. The intuition for the separating equilibrium is that the final offer arbitration game has a built-in penalty for being too aggressive. So as we talked about earlier, if you're too aggressive, there's a reduced probability of your side winning. And so that reins in the tendency towards aggressiveness. Okay. Now, what are some properties of the delta U and delta E? First, the more uncertainty and the more room for disagreement there is, the more exaggerated or aggressive positions the two sides will take. And so the offers will be further apart. So meaning that the distance between the final offers given by delta U plus delta E will be strictly decreasing in the precision parameters, H and H epsilon. Another property that we show is that when the party is more risk averse, then it will be more moderate or conservative in choosing its offer. That means a smaller delta. And so it's going to win more often in arbitration because moderate or reasonable offers are more likely to be accepted by the arbitrator.
So Yunmi, just a question. So when there's also the effect on what's going to be the risk aversion of the other party, right? So like if the union becomes more risk averse, I understand that their delta is going to be smaller, but I would assume something is going to happen with the employer, right? So the employer is going to take advantage of that and do more extreme offers.
So what we find when we actually simulate it is that, so let's say the union becomes more risk averse and becomes more moderate. In response to that, the employer also moderates, but not as much.
I see.
Yeah.
So the sum of the deltas shrinks. All right. Right.
Yes. Okay. So that's the arbitration model, and that will be the main model in our paper. But as I was saying, we would also be like to give some insights on how this arbitration process affects negotiations or negotiated outcomes.
Is there any learning? I know that there is some dynamics regarding the negotiation phase, but I wonder to what extent what happened in the previous negotiations would affect how they interpret the situation here, and to what extent do you really think this is a kind of a static situation that each time is separate from the past and so on and so forth?
Oh, I see. Yeah. So that's a good question. Since the employer, which is a municipality, and their police officers, they're always together in this relationship, and they're in it for many years. So there's probably some repeated game kind of aspect that could be relevant in, especially when they're deciding whether they should arbitrate or not, perhaps. But we do not account for dynamics in this paper currently.
Okay, but do you think that that might be something relevant when you focus on this static framework? Any substantial loss, missing the.
I think in the arbitration model that I've introduced so far, I do not believe that there was anything here that should substantially change just because they've played this game before. I don't know if you think there's a reason that it should. I think maybe the negotiation stage model that I will introduce, possibly it could, but there are ways that I've thought about that. But in this model so far, I'm not sure I see.
Yep.
Yeah. So I'll explain to you our negotiation model. It is a stylized model, but I'll tell you what it looks like. So the goal for this negotiation stage model is for us to be able to at least give some direction on how having arbitration as the disagreement outcome affects the negotiated outcomes. So if the case goes all the way to arbitration, the wage increase resulting is called Y. And from the party's perspective at the negotiation stage, this Y is a random variable because of all of the uncertainty involved. But beyond the wage, what will the arbitrated wage increase will be, there are other things that can affect the desirability or undesirability of arbitration for the parties. So we are going to let the union and the employer have costs called CU and CE for going into arbitration. You can think of these as the monetary as well as non-monetary costs of negotiation failure. So these can include things like arbitrator and lawyer fees, but also the time delays of the contract, which can take months, also effects on employee morale, political considerations, etc. These arbitration costs are privately known by each party, and we let the union and the employer each have different distributions of costs. These things affect how much the parties are willing to concede in the negotiation. Okay, so if you think about now the union's willingness to accept a settlement offer, the union will reject a settlement offer sigma if it's less than Y tilde, which is the union's certainty equivalent of arbitration minus its arbitration cost, which is the same as saying the arbitration cost of the union is less than Y tilde minus sigma. But the union's arbitration cost is its own private information, and the employer does not know what it is, so the employer doesn't know the union's willingness to accept. So the employer will need to make a settlement offer, sigma, without knowing or being certain about the union's willingness to accept. What happens is that if the union rejects the employer's settlement, then they will go to arbitration, they will get paid the arbitrated wage, and then the employer will need to pay the arbitration cost CE. But if the settlement offer is accepted by the union, then the employer just needs to pay the settlement amount, sigma. And so the employer will choose a settlement offer, sigma, to maximize this objective. And this leads to a first order condition for the employer's choice of the settlement offer, sigma. And we show that the equilibrium settlement offer, sigma, is higher when the employer's cost of arbitration is higher, when the expected arbitrated wage is higher, and when the union certainty equivalent of arbitration is higher. Okay. And so that's the negotiation stage model that we have in order to just be able to give some insights on, what effect does the arbitration stage have on the wages that are negotiated. So very briefly, I will talk about identification of this model. The observables that we have with which to identify the model primitives that we've mentioned so far are, first we see whether a given case was arbitrated or not. For the cases that were arbitrated, we see the final offers of the union and the employer, and we observe the arbitrator's decision, Y. For the cases that didn't go to arbitration and settled, we see what the settlement amount, sigma, was. We also allow the model primitives to vary with observable case characteristics. For example, in some time periods, the inflation rate was higher, so the average wage increase is higher, so we control for these types of covariates in our empirical analysis. What's
Yunmi, sorry,
yeah.
I'd like to ask you a question on the observables. Don't you observe how long it takes, like the negotiation stage? or does it always take the same length for every case? See what I mean? If it takes too long, it seems that, you know, like
I see. Yeah. So no, we
time discount.
We don't observe at what point, if they settled, they settled. We just know that if they fail to settle within 60 days of the new contract date, then they must go to arbitration, is the law. But we don't
have any dates, right, of when they started, when they finished this.
Yeah, we don't know that.
Okay, thank you.
Yunmi, I got a problem on my internet here. I'm not sure if I follow how is the update between what you propose during the negotiation and what you offer during the arbitration? Is there any connection between those two, or they treat as separate?
We assume that there's no constraint in the sense that the final offers can be chosen to be whatever they want, regardless of what settlement offer was offered.
Is there any value for them to use the information that comes from the negotiation phase in order to make better offers?
So what we hear from the practitioners in New Jersey is that, I guess there's probably like continuous contact in a way that happens between the employer and the union. And by the time that they write their final offers, there's basically no information that one side knows that the other side does not know. So when I as the union write the final offer, I am aware of what final offer the employer will offer. And so
I see. Yeah. So the way that you're modeling is that remaining noise is what is driven the offers that they make in the arbitration phase, right? They get a lot of information during the process, and then the remaining noise is what is associated with.
They're uncertain about what the arbitrator will think, right? And so they are playing strategically make offers to best respond to the arbitration itself.
Okay, got it.
Yeah. So when it comes to the arbitration model, we show that the arbitration model is identified, and just to give you some quick intuition for where that identification comes from, they're all tied to the properties of the model that we showed. So for instance, the difference between the unions and the employer's offer, the offer gap, that is strictly decreasing in the precision parameters. That helps us identify the distribution of the precision parameters. The probability that the union will win arbitration conditional on the offer gap, this is strictly increasing in the level of the union's risk aversion. That helps us identify the risk aversion parameter. Also, there is a relationship between the mean and the variance of the prior distribution of the fair wage and the mean and the variance of final offers conditional on the offer gap. So those help us identify the arbitration model. And we also show identification of the negotiation stage model, provided something that will shift the expected arbitrated wage without affecting these arbitration costs. So what we're trying to identify from the negotiation stage are the union's arbitration costs and the employer's arbitration cost. Very quick intuition for how to identify those. The employer's cost distribution is identified from the fact that the settlement offer sigma is monotonic in the employer's cost, and the union's cost distribution is identified from the fact that the response of the settlement offer to shifts in the union certainty equivalent of arbitration that informs us about the shape of the union's cost distribution. We can discuss more about this later after the seminar if you'd like, but I think I will need to move on to the post-estimation analysis because there's a lot of stuff there. So let me move on to the post-estimation analysis. Our estimation is very closely based on our identification argument. Okay, so I will get to the post-estimation analysis. So first, the first question we had was, what are the effects of risk attitudes on the wage increases that happen here? We do find that the union is risk averse in our estimation. And so what we do here, in order to see what was the effect of the union being risk averse versus it being risk neutral, is we use our estimated model to counterfactually simulate what would have been the case if the union was risk neutral. And then we use that as a risk neutral baseline against which to compare the risk averse outcomes. And what we see, and this kind of touches on one of the questions that were asked earlier, in row A, you see that when the union's risk averse in the left versus the right, the union asks for a lower wage increase. And then in row C, as a result of that, the union wins more than half of the time when it's risk averse because it's making now a more reasonable offer that the arbitrator is more likely to accept. And as a result of the higher win rate, if you look at row D, the average arbitrated wage increase, it's higher when the union is risk averse. However, when you then take a step back and you look at the union's ex ante certainty equivalent of arbitration, the risk premium is sufficiently high that the union's certainty equivalent of arbitration is lower when it's risk averse, even though the mean arbitrated wage is higher. So there's this, And because of that lower certainty equivalent, that weakens the union's negotiating position in the negotiation stage. So in other words, because of this lower certainty equivalent, the union now has a lower threshold for accepting settlement offers in the negotiation stage. And this in turn leads to lower settlement offers from the employer, given the employer's optimization problem. So that's what you see in row G. The mean settlement amount is lower for the union than the risk-averse union than the risk-neutral union. So overall, when you average across cases that settle and cases that arbitrate, ex-ante expected wage increase is lower when the union's risk-averse versus when it's risk-neutral. So there's this interesting distinction between just looking at the arbitration game in isolation versus considering the two-stage process. There's different effects on the more risk-averse party. The second question we had was about comparing these different arbitration designs. As I was mentioning earlier, there's two most popular types, final offer and conventional. In final offer, the parties' offers directly affect payoffs because one of the offers must be chosen as the award. But in conventional arbitration, there's no constraint on the arbitrator's choice. So the offers may only matter indirectly through the information that they convey to the arbitrator. So the offers in conventional, and that's the definition of a cheap talk game. So the offers in conventional arbitration are cheap talk, unlike FOA. In this comparison, we are not going to take a stance on what kind of equilibrium is being played in conventional arbitration. We will try to exploit as much as possible the fact that in 1996, conventional arbitration replaced FOA as the default procedure. So what we're going to do is we're going to simulate our estimated FOA model for each of the conventional arbitration cases that we observed from 1996 to 2000. And then we are going to compare the simulations to the observed conventional arbitration outcomes. I'm going to skip some things. So first, one of the differences that we see between conventional arbitration and final offer arbitration is that the variance of the arbitrated awards is higher in final offer than conventional. So this goes back to a prediction made by Stevens in 1966. So Stevens was the initial proposer of the FOA design. Stevens predicted first that the variance of arbitration awards would be higher in FOA than in CA, and this we confirm in our analysis here. Stevens then said, because of this higher variance, the FOA would lower the certainty equivalent of arbitration and thereby encourage settlement. But we actually find that given the estimated level of risk aversion and the magnitudes of the variances involved, actually the differential impact on the union certainty equivalent of these different variances is relatively minor. And so for the second part, not quite. So Stevens' argument is not a major factor in New Jersey when it comes to comparing these two designs. Another big difference that we see between the conventional and final offer arbitration is the difference between the union and the employer's offer. The offers in conventional arbitration are a lot further apart. So the two parties take more exaggerated positions in CA. And this is interesting in light of the fact that conventional arbitration is a cheap talk game. The fact that the offers are further apart doesn't necessarily imply that these offers are less informative as signals of the fair wage, but it is suggestive. So that's what we try to investigate next. And so we're going to try to quantify the amount of information transmission in CA versus FOA. We are going to define something called SP star and let this denote the signal, whatever it is, that is inferred from the offers by the arbitrator. And you can think of the degree of information transmission as being represented by the precision of this SP star. So when SP star has high precision, it means that information is transmitted well to the arbitrator. But the other extreme case could be that it's a complete pooling equilibrium. SP star is not informative at all. Then that's equivalent to SP star having precision 0. So depending on how high or low the precision of this SP star is, there's more or less precise information transmission. So what are the implications of better information transmission? Well, in conventional arbitration, we know that the arbitrator is not constrained. So she gets to impose her updated expectation of the fair wage, YA, directly. Recall that in FOA, she just chose the offer that was closer to YA, but now she's not constrained, so she can impose it directly. Now, the more precise the signal SP star is, we know that from learning models that the more weight will be given to it in forming an updated expectation. So when the amount of information transmission, let's call it alpha, is higher, then more weight will be given to SP star, so it will explain more of the variance in the arbitration award. So suppose we were to regress YA on SP star, then the R squared of that should be increasing in the degree of information transmission, alpha. And we are able to show that this is true in a simple case without any covariates in the regression. And then we also confirm it numerically when we include covariates in the regression. But anyway, what we could do to try to measure the amount of information transmission in conventional arbitration is to see what level of alpha best explains the R squared that is observed in the observed conventional arbitration data. So that's the approach that we take. We first take the observed CA data. When we regress the arbitration award on SP star. Of course, we do not observe SP star directly in the CA data, but it is a function of the two final offers or two offers made by the parties. So we will substitute a fifth order polynomial of the unions and employers' offers for SP star, including interactions. And we obtain an R² number. It doesn't matter what the exact number is, turns out it's 0.584. So what is the value of alpha, or the degree of information transmission, that would explain this R²? Here we leverage our estimated model, or our signal structure to be precise, to simulate Monte Carlo samples of SP star and YA for each value of alpha on a grid. And then for each of these Monte Carlo samples, we regress YA on SP star and store the R². And we find that the R² that best explains the observed the value of alpha that best explains the observed R² is 0.42. And to interpret that, it means that the information that's transmitted by the offers in CA is less than half as precise as the information that's transmitted in FOA. Okay. I have more details on that I can discuss after the seminar. So now to have a kind of, so far we've talked about a lot of different dimensions of comparison, but as a final, maybe more comprehensive criterion, we consider something that we call efficiency. And as our measure of efficiency, we're going to use the arbitrator's objective function. The arbitrator wanted to set the arbitration award as close as possible to S, this notion of a fair wage. The reason we call this efficiency is because if the arbitration award is very far from the fair wage, then it can lead to a misallocation of labor and resources, etc. But whatever you call it, we'd like to compare this measure for FOA versus CA. On the one hand, we just saw that FOA has better information transmission than CA. But on the other hand, this does come at the cost of the one or the other constraint in the FOA design. So what we do is we simulate this measure of efficiency for FOA using our model. We also simulate it for CA using the alpha measure, alpha equals 0.42 that we just estimated in the last exercise. And what we find is that on average, conventional arbitration is more quote unquote efficient. The gain from the arbitrator not being constrained outweighs the loss from the inferior information transmission in CA. So on balance, in our application, we find that it's worth sacrificing this extra information that you would get from FOA in order to free up the arbitrator's choice. And by this criterion, at least in our application, it does seem like conventional arbitration is the better choice than FOA.
Yunmi,
Yes.
very nice that even though you don't have an equilibrium, you don't have to make an assumption on the equilibrium of the CA game, and still you can get an estimate for alpha, right? But it would be interesting to see how robust these last findings are with respect to alpha. So for what ranges of alpha the CA dominates sort of the welfare comparison puts the CA ahead. So to get a sense of how fragile this conclusion is, right?
Okay, yeah, that's a good suggestion. We'll take a look at that. Thank you. Okay. So looks like time is almost up, so I will go ahead and go through my concluding slide. So in this paper, what we did was we combined theory and empirics to advance the understanding of arbitration and dispute resolution. We had a model of three-way strategic interaction, which incorporates asymmetric risk attitudes of the parties, learning by the arbitrator, or strategic communication, and we supplemented it with a negotiation stage. we establish identification of this model from the parties' offers in arbitration, the arbitration awards, and the settlement amounts. Some interesting things we found were that what are the effects of one party being more risk averse? Well, it depends whether you're just looking at the arbitration game itself or whether you're looking at the two-stage process more broadly or holistically. The comparison is different. Also, we compared for two different arbitration designs, the disputing parties' behavior, the arbitration outcomes, the information revelation that happens, and this efficiency measure that we just looked at. Overall, it does seem like that, at least in New Jersey, CA seems to be the better choice in light of all the comparisons that we have made. So that's all I have. I'm open to any questions that you have, and I'm happy to stay longer for any additional questions that go over time.
May I ask a question?
Yes, of course.
And coming back to the dynamics, the importance of modeling or not modeling the dynamics of the situation. It seems to me that it would be very hard for the arbitrator to identify the risk aversion if there is no kind of repeated game there. So I know that you explore the monotonicity of the equilibrium to get it, but I don't know. It seems a bit artificial as far as how an arbitrator would deal with the situation. I would like to listen a little more of what you have in mind.
Okay. So to restate your question, just to make sure I understood it correctly, you're saying that, well, the arbitrator's inference rule must depend on, it depends on the two parties' offer strategies, and the two parties' offer strategies depends on, whether they're risk averse or not, or how risk averse they are. So in order for the arbitrator to make the correct inference, she must know the correct utility functions that the two sides have. And the arbitrator would need to have a lot of experience over multiple cases in order to have a good sense of the risk aversion of the union versus the employer. Is that the question?
Yeah, that's what I have in mind.
Yeah. So yeah, we're kind of our thinking is that, so the risk aversion, given certain covariates, that there's some level of risk aversion, and the arbitrator, through a lot of experience, has learned what this is, or that equilibrium has already been reached, in other words. And so we don't model the process by which, over many cases, the arbitrator learned it, but we assume that the arbitrator, over a lot of experience, has already learned it. Yeah, but we don't model the process by which, over time, that was learned.
I think that you perhaps might have data on the arbitrator, and you could somewhat test whether this dynamic element is really relevant or not. And I think it would be interesting. That's why I asked. I think that would enrich, like, instead of exploring only the equilibrium results that require a lot of rationality, common knowledge. If you get the characteristics of the arbitrator, you might make this inference, whether it matters or not, or if the results change, if there is a whole new arbitrator that was not part of the game before. I don't know. I think it might be interesting to explore a little bit this idea.
Yeah. That's right. Good point.
Good. Is there any more question? No. So thanks a lot, Yumi. And it was a great presentation. And it was very nice to speak with you as well. And thanks.
Yes, thank you. Thank you all for listening.
Thank you very much.
Thank you. Congratulations. Very good paper.
Congratulations.
Thank you. Bye-bye.
Thank you.
Thanks.
Bye.
Thank you.
Oh, I'll stop sharing.
Yes, you can. Bye-bye, Yumi.
Bye.
Mhm.